Judge Zone.
Good morning, Tom Zone, Chief
Morning.
Superior Judge. I agree with Senator Sears, what you ended with at the last section, and that was that the pilot project is going well. We'll get you more information on that in the future. Judge Corsones is doing a great job in Bennington with the Department of Corrections, State's Attorney, and Defender General, Public Defender's Office. The issue on venue sounds like everyone's in agreement, and that actually ties in. I had to smile yesterday when Senator Nitko was speaking about the letter from Judge Mello that she mentioned at the end of one of her sessions. This was the docket that Judge Mello was referencing. And so the 90 plus cases, this was it. And that's, it's nice to hear that it seems as though everyone's agreeing that perhaps having a venue that spreads things out is a better way to go. As far as the issue of the preparation of paperwork for the Department of Corrections, we certainly don't want to see them have to make filings if it's unnecessary. And it sounds like Mr. Valerio had some ideas there that maybe we could work something out with everyone to make sure that DOC doesn't have to put together other paperwork. The other changes that DOC puts forward are changes to what the legislature put together in this statute. I wasn't part of the discussions as far as appearing and testifying. That took place before I came in. And when I look at the statute, the question that the court has and judiciary has is, well, what is the intent of the legislature? What is the policy? If the policy of the legislature is that it does not want judges to be able to find an abuse of discretion and lessen the amount of the interrupt, well, then the section that DOC wants to put in, you would want to put that in if it's not reflecting what the intent of the legislature is. If the intent is to have other limitations on the statute, well, then you'd make other changes that the Department of Corrections is seeking. But the real question for the court is, what is the policy that the legislature wants to go forward on with this? And does the statute effectuate that policy? Right now, courts are making decisions. I know that there are decisions where judges are finding an abuse of discretion based upon a determination that the interrupt is excessive in length. More than half the cases, I understand, are coming from cases alleging absconding, where the commissioner almost always issues a warrant, I understand. These are policy decisions for the legislature to decide what is the scope of the relief that you intend to afford individuals who are in the category of the furloughs that are subject to this rule in the statute. If you adopt what the Department of Corrections is advocating, it will significantly limit the scope of review and the amount of cases that the courts are going to see. That's up to the legislature. What's the policy that the legislature wants to go forward on? It would be a significant change. But again, I don't feel comfortable weighing in on the policy. The real question is, what is the policy? And does this statute as it's written effectuate that policy? And if the answer is no, then the changes that the department is seeking, if they effectuate your policy, then they're appropriate. If the answer is yes, that it's effectuating the policy, then maybe as significant changes aren't there. So it does seem to me, when all is said and done, that if the intent of the legislature, if the policy was, we want to have a review system that is not merely a rubber stamp and that may give rise to differing views of courts through a, if you will, a second set of review, that, from what we're hearing, seems to be what's occurring, because there are a number of cases that the Department of Corrections determinations are being overturned or modified. But again, it's a policy determination for the legislature of what is it that you want this provision to provide for the inmates on furlough.
Hey, well, thank you. We're going to pick up with this when we get back on March 8th. I don't know if it'll actually be on March 8th when we take it up, but we will take it up. We appreciate all the testimony and a better understanding now of what's happening and where the real disagreement is. I think it's clear to me anyway. Much clearer to me now, the Rule 74 concerns, and I understand the perspective of the Defender General, the Department of Corrections, and the Judiciary. So appreciate very much. And we're going to shift to S-254, which is the bill dealing with qualified immunity. And Ben has redrafted the bill based upon some of our conversations the other day. And it's draft 2.1, dated today at 9:03 a.m. And you can get it on the committee website, or Ben will walk us through it. And I'm sure he'll share the screen to go through it.
Yes, thank you, Senator Sears. Ben Novogrodsky for the Office of Legislative Counsel. I'm happy to share my screen, and I'll do as quick of a walkthrough as I can.
Well, I don't think you have to, we've got, I'd say 30 minutes. We want to get done by about 20 to 25 after 11, so we can move on to the next meeting.
Well, I could do then just a broad overview, and then kind of follow along on the screen so that you know exactly which sections I'm summarizing.
Okay, that'd be good.
Okay, can everybody see my screen?
Yes.
Okay, so
everybody can. I can.
So yes, this is draft 2.1 of an amendment to S-254. Essentially what this does is that this incorporates an intent section that clarifies that the defense of qualified immunity is replaced by the Zulo standard, and one that the plaintiff must prove in order to obtain damages in an action brought pursuant to this chapter. And that would be in section 5607. Section 5608 concerns the liability of law enforcement officers and limitations. This is the right of action itself. In subsection B, the scope has been narrowed to only include violations of an individual's rights, privileges, immunities, guaranteed under the Constitution of the state of Vermont. In order to obtain damages under subsection C, this is the Zulo standard, in the attempt to codify it. It says that the plaintiffs must show by preponderance of the evidence that the law enforcement officer acting under authority of the state or within the scope of authority of a law enforcement agency committed a violation of subsection B, which would be a violation of constitutional rights. The second prong would be that there's no meaningful alternative in the context of the particular case. And the third prong is that the law enforcement officer acting under authority of the state or within the scope of authority of a law enforcement agency knew or should have known the officer was violating clearly established law, or the officer acted in bad faith. Subsection D clarifies that qualified immunity is not a defense to suit or liability available to a law enforcement officer. So again, this would not be something that they could use to prevent a lawsuit or to prevent liability. Rather, it's shifted to that damages limiting principle under Zulo for the plaintiff to prove. Subdivision 2 explains that the prohibition on the use of qualified immunity does not change the availability of other types of immunity, judicial or legislative. So those are immunities that if a police officer was testifying in the legislature or was testifying in a court case or something of that nature, that's not affected by what's going on in this statute. And that also does not abrogate any statutory or common law immunity that's not covered by this statute as well. So this would leave untouched the Vermont Tort Claims Act, municipal immunity, and those other forms of immunity that we've discussed at length. In subsection E, this is a cap on damages for the law enforcement officer. This is sort of in line with the Zulo consideration, balancing a flood of litigation and also the concerns raised by previous testimony about protecting police officers from financial ruin, essentially. And so this is similar to a cap that exists in the Vermont Tort Claims Act, but also under the New Mexico version of this bill, where it's a maximum liability of $500,000 to any one individual with a maximum aggregate liability of $2 million to all individuals arising out of each occurrence. Subsection F says that this remedy is one of many. It's not exclusive. And so if there are other remedies available under the law or pursuant to common law, they can be pursued. This would be a claim under the Vermont Tort Claims Act for a non-constitutional tort. That would be another remedy that could be available against the state. Subsection G is the attorney.
Ben, can you help me with E and F again?
Sure.
F is here. But this is the action for damages, but it isn't the individual law enforcement officer. It would be the community or the state.
Well, so the action can be brought against the law enforcement officer, and later on you'll see that there is the complete indemnification of the law enforcement officer. So an action could be brought against them individually. A court could issue a ruling saying that you're liable for no more than $500,000 to any one individual. That would still be indemnified by the law enforcement agency. So it's against the law enforcement officer individually, and the liability that can be issued in that ruling against them individually. But later on, there's an indemnification provision that completely indemnifies the law enforcement officer by the agency.
Okay.
Senator Sears, could I ask a question about that?
Yep.
Ben, if I understand that correctly, maximum aggregate liability shall be $2 million to all individuals arising out of each occurrence. Taking the case of George Floyd, what would that have done?
So in that case, the maximum amount that could have been awarded is $2 million if, well, I think that they're depending on how many individuals, right? But the most that could have been awarded in that case to the victim's family would be $2 million. But if it was only against one individual, it would be a $500,000 maximum. So let's say you have 5 individuals. And individually they could have had a $500,000 liability. Since there are more than that, the liability couldn't have been more than $200,000. So it caps it that's the maximum that you can get in a case at all. But if it's just one person, the maximum that can be had is $500,000.
So I'm just thinking about the municipality that paid the Floyd family, if my memory is correct, $47 million. This would have blocked that completely and kept it at these caps. Am I correct?
Correct.
Okay.
And also later on that there is a provision that the indemnification that the law enforcement agency amounts that the agency would have to pay mirror these caps as well, so that there's no so that it's clear that they're in line with each other.
This is New Mexico law.
This is the caps are similar or the same in the New Mexico law. This is also derived from the Vermont Tort Claims Act, has the same caps as well.
So if we did nothing, they would still be limited to the 2 million if we didn't do this bill at all.
Well, that's if it would. So the Vermont Tort Claims Act would be torts like negligence and other common law torts. This is about the constitutional torts that we've been talking about. And under the Vermont Tort Claims Act, you can only bring a claim against the state. You cannot bring a claim against an individual unless it's for gross negligence or other conduct. But this is a different remedy.
Okay, I'm trying to better understand Senator Benning's question and better understand what would happen if we don't do this at all. If there's no bill, it's the same cap. Is that correct?
Well, if there's no bill, qualified immunity would still apply. And
Okay.
it would be used as, a defense to suit or liability.
But what would the cap be?
There is no cap that's
Okay.
listed right now.
So this is not necessary, or is it?
Well, that's a policy decision for the committee, and
Right.
the reason why I put this into the bill was just to hearing the concerns of other testimony, and I think the proponents of the New Mexico version as well. And given that this exists in other parts of Vermont law, it seemed like a sensible addition, but it does not have to remain.
Okay, thank you. Senator White.
I was just going to say that, but Ben said it before me, this mirrors other Vermont law. And because you said in other cases, and I don't really understand the word tort, except that I think it's some kind of a rich cake. But other than that, I think that this mirrors other language. And so I don't know why we wouldn't leave it here.
Okay.
I can move on to subsection G.
Yep.
And this concerns the attorney's fees provision. So the first clause remains unchanged. The second one concerning the defendant. So when a judgment is entered in favor of a defendant, a court may award reasonable attorney's fees and other litigation costs reasonably incurred to the defendant for defending any claims the court finds frivolous, brought with malicious intent, or in retribution for otherwise lawful conduct. The language here is intended to capture those other cases that are really brought for no reason beyond just so frivolous would be without merit altogether, but these would also include cases where maybe there was trying to bring intentional harm to the law enforcement officer, malintent, or in retribution for something that they did that was lawful, but for whatever reason the plaintiff was disgruntled and was trying to use the court system to their advantage. So that's the intent of including this type of language.
Okay.
Scrolling down, subsection H is just the cause of action has a 3-year statute of limitations. So that's the same as before. Section 5609 is the notice of claim that was discussed yesterday. So this would be essentially a separate filing that would have to be filed well ahead of the lawsuit, basically giving the law enforcement agency notice that there could be an action filed. And what this would do, it's a condition precedent. So what that means is that this has to happen in order for a lawsuit to be filed. It would have to happen within 1 year after the occurrence happening. And that would not include any time for which the claimant may be incapacitated due to injury. So it would have to be a written notice of claim. It would have to include the name and address of each claimant and their attorney if they existed, the nature of the claim, the time, place, and manner in which the claim occurred, the damages or injuries that were sustained, and then it would have to be a sworn statement. It would also have to then be served under subsection C on the law enforcement agency, either personally or through regular certified mail to someone that's designated by law to accept a court summons, or through the attorney regularly representing the law enforcement agency. Subsection D considers the situation where there may have been a wrongful death claim, and it gives the representative of the decedent's estate the ability to file the notice of claim. It extends it by 6 months, so they would have a 1.5 years to file the notice of claim or to serve the notice of claim. And it also clarifies that if it was already done by the decedent before they died, they don't have to file another one. Subsection E requires the law enforcement agency to maintain a record of all notices that are filed and compile them, and they'd be subject to the public records law unless an exception were to apply. Section 5610 is the indemnification provision and also a record of disposition of cases that were disposed, so that made it to judgment. This essentially says that a law enforcement agency shall fully indemnify a law enforcement officer for any liability incurred through a judgment or settlement for a claim that arose under this section. Subsection B is what I mentioned before, to clarify that the liability limits that law enforcement agency would have to pay would mirror those of the law enforcement officer individually. So they are not on the hook for anything more. They just have to pay exactly what the judgment was. And then subsection C is that record of final judgments and settlements. Each law enforcement agency shall maintain that record, attach a copy of the complaint, and then all those judgments, settlements, and complaints are subject to disclosure under the Public Records Act unless an exception were to apply. And that's the summary of the second draft of the amendment to S-254.
Okay. Okay, are there any questions from the committee or comments?
Are Senator Sears?
Yeah.
Are we intending to vote on this today?
No,
Oh, okay.
no, my intention is to hold hearings on it.
Yeah.
The week of the 8th.
Oh, okay.
I don't know the exact date. And those witnesses that have spoken before are more than welcome to comment on the redraft, either in favor or opposed, or mildly in favor or mildly opposed, whatever they'd like.
Okay.
But this gives us over a week to review the bill, for people to make suggestions on improvements, but it narrows the scope. The intent here is to narrow the scope to constitutional violations, somebody's constitutional rights, for example, against search and seizure. The second is to make clear that Zulo applies to all law enforcement in the state. There is some question about that, and it also responds to the Supreme Court, Vermont Supreme Court's suggestions that the legislature may want to look at this issue of qualified immunity that they expressed in the Zulo decision. And that's basically, I think, where it comes from. So there are several things that were already pointed out this morning. For example, the caps. Should there be caps? Shouldn't there be? Those are policy decisions that we have to make based upon what we hear from others. I expect there will still be opposition to the bill. Doesn't surprise me in the least if there is. But I want to make clear that, number one, some of the concerns expressed by folks in opposition to the bill as introduced, we've tried to address some of those concerns, particularly those of police officers who were worried about having to be individually liable and not being, when malicious or other types of claims were brought. The individual police officer is no longer liable. It's the agency as it is today. And qualified immunity still exists. The example from the attorney for the city of Burlington, police officer stops traffic on the road. Don't know that it's a civil right to be able to drive on the street. And then somebody has an emergency and can't get to the house. So that's basically, I don't know. That's my summary of it. Ben, are there any other? Yes, Senator White.
I just would like to say that wherever we land with this, I appreciate the ability to have the time now to digest this and look at it more and then come back. So thank you.
Well, you're welcome. Certainly. Well, you know, but it wouldn't be the end of the world to break early. I don't know that if I started to take testimony on it this morning, we would not get to everybody who might want to speak, and that would create a problem. But again, are there any questions from the committee on the draft? Any further questions?
I think I'll have a lot of questions when I hear some of the witness testimony in response to the new draft. I've just read this for the first time, and I feel like I could probably formulate a few dozen questions, but I'm just not feeling prepared to do that, having seen it now for the first time. Frankly, it felt to me like we were trying to build an airplane while it was in the air, but I'll have a lot of questions, Dick, but just not right now. I'm just not ready to formulate them.
Okay. Ben, Senator Nick, yeah.
Are there any parts of the other bill that remain?
I mean, it is almost a completely different bill. You know, there are aspects that do remain, specifically, you know, the right of action against the police officer, just how broad it is has changed. Also, the attorney's fees available to a plaintiff, that change has that is not changed. And I mean, that's essentially it. I mean, the statute of limitations is the same as well. But it is outside of that, it's almost completely different.
Okay, thank you.
And I apologize for just getting it to you this morning. It's just you know, how the cookie crumbles a little bit.
Well, it's a busy time for people that are doing the drafting around here.
Yeah.
Oftentimes, I don't know how you all do it. When you've got two committees or more looking for and multiple bills to work on. Like this morning, you had two bills in here. All right. Well, I think we're gonna break for 10